Hello, everyone. Welcome back as we explore the Washington Constitution. Today, we've got an exciting subject. What does Washington's Constitution have to say about free speech? And in particular, what we're going to focus on today, there is a lot of free speech that we see in the federal Constitution that's been developed through that arena. There's been some, though, that has been developed in Washington's Constitution. So I want to talk through that. In our Washington's Constitution, we're going to find it in Article 1, Section 5, and we'll get into the exact text. But one of the things I want to lay out there is Washington's Constitution cannot go any lower than the federal Constitution. So if you've got the federal Constitution guarantee of speech, and we'll get to why this is, it's here. Washington Constitution must be on parity or higher. And what we're going to find is Washington's Constitution protects speech. Actually, you're going to hear that it is the premier or one of the preferred freedoms in Washington is speech. We'll talk a little bit about why and then some of the cases. So come join me as we go into this discussion. I did a little PowerPoint like I did in the last time. And I want to show I want to start with something that I really like in this one of the quotes I really like and really enjoy is the histories of the United States and Washington constitutions clearly demonstrate that the protection of fundamental rights of the citizens of Washington was intended to be and remains a separate and important function of our state constitution and courts that is closely associated with our sovereignty. We talked about that in the last one, but I think it's more important or equally important as we roll into the cases talking through speech and the right to speech in Washington and what's protected by our Constitution as opposed to just federally. And one of the cases, this case we'll talk a little bit about of State versus Co., how this comes up, but this is a free speech case. And again, we go back to Washington's Constitution has a separate and important function in our state to protecting your fundamental liberties. What a powerful statement. How awesome is that? Okay, so if we're going to talk about the Washington State Constitution on speech, let's then talk about the first piece. How does it reflect with the federal? And we got to go back to the language, because the first thing in interpreting any constitution is language. And I started in the last one where we talked about, remember, the federal constitution is broad in our geographic expanse. It runs across the nation, sea to shining sea, and sometimes beyond. But it's delegated and narrower powers. It's not broad plenary powers. And we see in the Constitution, when we look at the First Amendment, it says, Congress shall make no law. And it goes on to respecting an establishment of religion or prohibiting free exercise thereof, or abridging the freedom of speech or of press or the right of the people to peaceably assemble and to petition the government for the redress of grievances. Now, this First Amendment right comes with multiple different things packed right into it. I mean, you've got freedom of religion, you've got the Establishment Clause, you've got the freedom of press, you've got the assembly, you have rights of association, tons of things within this statement. But very little of it, actually, in the words itself, talks of speech. Congress shall make no law, abridging the freedom of speech. That's a relatively narrow statement. Who should not make a law? Congress. And we'll see why this now applies to all government agencies. And it applies to states. We'll find out why that is. But originally it starts off as a restriction on Congress shall make no law. And that'll be an interesting thing as we explore into the Washington Constitution. But then it says abridging the freedom of speech. So the freedom of speech in the U.S. Constitution exists as a fundamental right, and the government is restricted from talking about it or from abridging it. And so what you're going to find there is that is a negative right. That's an interesting statement. It's a negative right. Your right exists, or it's a negative statement. Your right exists and the government can't restrict it, okay? And remember, this is a statement on a boundless geographical area, but enumerated and limited powers. And that's important, because let's go on to what then does the Washington Constitution say? Well, Washington's Constitution goes in Section 5, Article 1, Section 5 of our Constitution has one specifically on speech. Now, there is a separate one on freedom on religion. We'll explore that one later. And there is a separate one on the freedom of assembly, petition, redress. And then there's a separate one on access to courts. So one of the things you find in ours is there's a specific section on freedom of speech. And this one says every person may speak freely, or may freely speak, write, and publish on all subjects, being responsible for the abuse of that right. Okay, that's a significant word difference. And I want to point out some of these significant word differences. And you'll see I highlighted, or I bolded one piece and underlined another, because we'll get into that. But it starts off every person. So not just some people, every person. Everyone, regardless of your citizenship, every person. And remember, Washington's Constitution starts off with thankfulness to our liberties, to our Supreme Creator. So the liberties come from our Supreme Creator. But again, what we talked about previously, Washington, its government and sovereignty is a plenary sovereignty. It's not enumerated. It reaches only to limited geographical borders. That's why I have the state up here. It's within these borders that every person may freely speak, write, and publish on all subjects. So the first key thing is it's got every person. And then it covers basically any way you want to do it. You may speak, you may write, you may publish. And what can you do it on? All subjects. And then we get into this other statement, being responsible for the abuse of that right. We'll talk about each one of those has a powerful thing, but I want you to see the difference of that and what we had just talked about with the federal Constitution. The federal Constitution says, government, you can't abridge this. Again, we're talking about it's already enumerated powers. Now it's just putting an extra restraint. Washington's Constitution, though, is a positive statement. We recognize that every person has a right to speak freely. And may, that key word may. There's no compulsion in your speech. You may speak freely and write freely. Okay, so that's a powerful statement. Those words matter. If we're going to start out finding out what this means, we should look at those words in and of themselves. So let's talk then, how does this work in the structure? Because one of the things we've talked about the words real quickly, but one of the things that I want to talk about is the structures of the various federal and Washington Constitution, because this will come up as well. We'll talk in a little bit on where these become more, where the Washington Constitution becomes more protective, but we need to talk on the structure. So in Washington's Constitution, we talked about this earlier, we've got the preamble. We, the people of the state of Washington, grateful to the supreme ruler of the universe for our liberties, do ordain this Constitution. And then right underneath there, it goes into Article 1, a Declaration of Rights. So in the Washington Constitution, that's where you find it. It is first there in that declaration. And we talked before, the first rule of that is all political power and governments are built to protect and maintain individual rights. And then bam, here comes this, and all people may speak freely. So what you have there in the midst of our Washington Constitution is up foremost in front. This freedom of speech just becomes right in your face. And that's the structure of the Washington Constitution. Before the government is talked about, before its powers come into being, one of the things that's out there is this Declaration of Rights, and we'll hit it more, but it's really important on this one. Your freedom of speech comes before the establishment of a legislature, comes before the establishment of a governor, comes before the courts, comes before the establishment of cities and towns. You have that freedom of speech as a high priority. What a beautiful thing that that's right up front. Before it even says, governor, you're coming into existence, legislature, here you are. It says every person shall have the right to speak freely, may speak freely on any subject. Okay. But in the federal Constitution, you're going to see it structured very differently. And we talked a little bit about its structure in the last one, but its structure becomes very important. We start off with the first piece of the federal Constitution, which is, we the people of the United States, in order to form a more perfect union. And then it goes into the establishment of Congress. Article 1 in the federal Constitution is not a preamble of rights. It is, Congress, here's your enumerated powers. And the reason it was built that way was the assumption that it left all the protection of the rights with the states. These were limited powers. It didn't give the government the power to restrict speech, so the government didn't have it. That was the original founding. But as many of us will remember, after the Constitution's passed, there's still a lot of fear on whether or not this government's going to start restricting individual liberties. What did we just fight for? Are we going to lose that? And so that's where we come up with the passing of the Bill of Rights. So here you've got this We the People Constitution, says government, you can only do these things. And by the way, restricting speech isn't among those things, so we're not super worried. But then the people say, we're worried, and we want a Bill of Rights. And as an extra restraint, we're going to pop in these Bill of Rights. And among these is going to be the First Amendment. And when this starts out, it is a restriction on the federal government. Okay? This is one thing we need to remember. When this starts out, states are not subject to these bills of rights and restrictions. They are restrictions on Congress, on the federal government. Congress has the power to start laws. Executive has the power to bring them out. Judiciary has the power to interpret. So if Congress has a restriction on making this, well, it's a restriction on all the federal government. You can't abridge freedom of speech. However, we're all familiar with the Civil War, and along comes the 14th Amendment. And the 14th Amendment comes forward and says, nor shall any state deprive any person of life, liberty, and property without the due process of law. You begin to have the federal government protecting the rights of the people, of the person inside states. And we get through this due process clause, the application still going on today, still being fought for today of what that means. But we do have a belief that now the Bill of Rights, the First Amendment, applies to the states through the 14th Amendment. And so the structure of the federal government on how it comes about is incredibly important in relation to the state, especially for the freedom of speech. The freedom of speech, as we see in the First Amendment, is now a restriction on state government, the same as it is on the federal government. But then we have the Washington Constitution that says, no, this is a plenary power. We're starting off at this thing. It's right there up front. Okay. So what does that do for us? Well, or how did we get to the Washington Constitution? How did we get to this place? Because I think we've talked about the actual words, we've talked about the structure, but how did we historically come up to every person may speak freely and publish on all subjects, being responsible for the abuse of that right? Because you'll notice that is significantly different than the First Amendment. And that's one thing to remember as you walk into the Washington Constitution. It is not the same. As a matter of fact, almost none of it came from the federal Constitution. If you look at it, one of the first, and I've got two iterations over here. These were first proposed iterations of the Constitution. And you can't read too much into the fact they were rejected, but you can read something into it. And the first iteration we have is that no law shall be passed restraining free expression of opinion or restricting the right to speech, write or print freely on, to speak, write, or print freely on any subject. This was the first draft of the Washington Constitution. And this is important. We'll get into a case that kind of talks about this in some interesting ways. But this first draft, doesn't that look a little more familiar, though, to the First Amendment? Congress shall pass no law abridging the right to speak freely or abridging the freedom of speech. Here, we equally have no law shall be passed restraining free expression. A little bit broader, but very similar. This gets rejected pretty quickly. And the next thing that comes in is this other statement, the one that replaces it. From a negative, like the First Amendment, to then they propose this: every person may speak freely, write and publish on all subjects, being responsible for the abuse of that right. That's pretty much where we end. Now, there was a second piece to it, though, that says in all trials for libel, both civil and criminal, the truth when published with good motives and for justifiable ends shall be sufficient defense. The jury has, I put in hat, but has, the right to determine the fact and law under direction of the court. Okay, that was the next proposal. And if you want to know where that proposal comes from, we pulled it not from the federal Constitution, but instead we pulled it from other state constitutions. We pulled very strongly from California's Constitution. We pulled from Oregon's constitutions. Remember, ours was formed in 1889. These are being formed earlier. There are even revisions. We pulled from the Indiana Constitution. And these all pulled from the New York Constitution. So there's a history of these going out in the states, and we end up with it being, well, we're going to drop this other part in trials, both civil and libel. We'll talk a little bit about that because that becomes a fight later on in an interesting application of Washington's Constitution. But that's the history of how we get here. We did not choose to take our Constitution framework from the federal government. So that means we have in Washington, for freedom of speech, we have a separate and independent contract or agreement with our government among our people that is way different than the federal government statement. And that's how we come out. We borrow more from other constitutions statewide than we ever did from the federal. And that's how we end up with every person may freely speak, write, and publish on all subjects, being responsible for the abuse of that right. That's how we got here. So I want to talk about a couple cases, because remember how I talked in our last discussion, or I guess our first discussion, that state constitutions are just being relatively new in being used for rights. And that really came about in the 70s with some, as we begin to explore more fundamental freedoms, the state constitutions are being said, let's look here. And at the early part of Washington's as of this new thing, finding fundamental liberties inside our state constitutions, let's stop looking at our federal and let's start looking more at our states. Washington's Constitution, as in the freedom of speech, comes first and foremost early on. And there's an interesting case, and I wanted to bring this one up, Alderwood Associates versus Washington Environmental Council. This case was probably at the forefront of what does freedom of speech mean, especially for states? Because one of the things that you'll see in the federal Constitution, we saw it, Congress shall pass no law. But that's not in the Washington State Constitution. There is no restriction on government. There is no requirement of government action to trigger it. For instance, there is nothing in there that says the government shall pass no law. Instead, it's an affirmative statement. Every person shall have freedom to speak. And so what does that mean when I'm going into a shopping center? What does that mean when I'm in the public square, but I happen to be on private property owned by someone else? I can tell you what it means in the federal government. In the federal government, there must be state action. The First Amendment restricts state action. So there was a real question as we begin to look at the freedom of speech in Washington. Does it restrict state action, or does it restrict everyone's action? And in Alderwood Associates versus Washington Environmental Council, what's happening is people are going out to supermarkets with petitions, and they're seeing if they can get people to sign petitions as you enter in and begin to sign these things. And these supermarkets are not liking that. They're like, no, we don't want you coming doing that. You're here to buy food. But it's also, that parking lot is kind of a public forum, kind of important place to be. And so if you're going to be out getting petitions signed, well, isn't that part of your every person may speak freely, right? So out comes a superior court, issues a restraint on getting these petitions signed inside that area. And the question is this injunction issued by a court legitimate? Well, that's the first question. And up this rolls through to our Supreme Court. And on our Washington Supreme Court at the time is an interesting justice, probably one of the best so far at developing out Washington State's Constitution. We've got a few more who've come around, but his name's Justice Utter. And we'll talk a lot about Utter because he's the one who, he went quite a bit into Washington State's Constitution, its history and everything. But as he rules on this, he comes out and says, hey, listen, you're going to notice in Washington State's Constitution that we don't have a state government requirement. So our First Amendment, or our Article 1, Section 5, freedom of speech, allows you to go into a public square and even into their property rights and speak freely. This is not just a right against government, it is a right against corporations and business. Okay, little interesting, because that just opens the floodgates. What does that mean? That means I can walk in and speak freely on your property and you can't kick me out? Is that what that means? Well, there's another thing that's going on, and we talked a little bit about in the last discussion, this freedom of petition, that Washington has this voting right, a deep right to get things to the people. And so this is a referendum that is going on. They're trying to get signatures on actual lawmaking, which is a right of the people, and that's going on as well. And so the court, in very much a plurality decision, comes out and says, okay, freedom of speech is a preferred right in Washington, and that preferred right, when it comes into interaction with another right, such as property, well, we can't say it overwhelms property, but the courts must now balance that right, especially when it comes to signing and gathering of petitions for referendum processes or initiative processes. And that's where that one comes out. Right afterwards, though, this just excites Justice Utter. He starts writing just a wonderful thing he's got this article that I love. And we pulled a bit from it, where he goes in deep onto the Washington Constitution, why it's not just a freedom of speech against the government, but it's a freedom of speech against everyone else. And no one can restrict your speech. Just awesome article. But, he can't quite convince the rest of his justices that this is the way we're going. And Alderwood, one of the key differences in Alderwood was it was overruling a court's restraint on speech. So the court had put this restriction on these people from speaking. Well, then about 8 years later, you get into South Center joint venture versus the National Democratic Party, where these people are literally going into a shopping center, into a mall, and they are handing out flyers in malls, and the mall doesn't want them there. So the mall security people start throwing them out. And so these people bring a claim saying, hey, look, you said in Alderwood that these are public town squares. We have a right to go in. You can't do this to us. And at that point, the court looks at it and goes, yeah, this could be a problem. We could end up in a lot of lawsuits if we start saying we got to balance property rights every time with this preferred right to speech. This is just weird. And so in South Center joint venture, the court comes out and says, listen, our Constitution is a restriction on the federal government, or sorry, not on the federal government, on the government. It is not a restriction or the governing between individuals. We leave that to positive law. So we are not going to hold that you have a constitutional right to speak in someone else's property. No. Alderwood, we're going to distinguish out that Alderwood case that because it was a part of the initiative process, the referendum and initiative process, we are going to say that it probably had more to do with, say, the voting right aspects of, or the legitimate legislative acts of the people than it did with speech. And we're going to back off this theory that your freedom of speech is restriction. It's everyone stopping it. No, your freedom of speech is a compact between you and the government, and we are going to require some government action. But what this may have left open in Washington, and we haven't seen it yet, is whether or not the legislature can pass laws showing a higher preference for speech than for people who own pieces of the public square. Interestingly, you see that down in Texas, where they passed a law like that regarding Twitter. We do probably have that opportunity here in Washington to pass such laws that public forums must respect speech, that if you choose to create a public forum, you must now respect speech. And that's because of the framework between Alderwood, South Center. There is no such law as far as I know. Most laws tend to restrict speech, but I would guess that that would not violate the Washington State Constitution if you choose to voluntarily create a public center or maintain one, that you would have to respect speech underneath every person. And that would probably be a valid activity under a Washington State Constitution. Just one of my thoughts as I read through those. So where do we find the differences in Washington's Constitution versus the federal Constitution? In particular, how does that impact your fundamental rights? And there's really in three main areas that we found it to be more protected. There's some that could change. Right now, I am currently hoping for a case to go up that talks about employee speech. Do government employees, what level of government free speech do employees have under the Washington Constitution versus the federal one? I think that'd be fascinating. Been briefing it out, working with some friends on it, and it's an interesting subject. But there's probably, I'd say, two main areas that we're going to see the Washington State Constitution protecting speech differently than the federal. So in the federal government, what you're going to find is the government can restrict speech, especially in a public forum, depending on what's called a significant interest. It says Congress shall make no law abridging the freedom of speech. Now, remember, our Constitution is not a suicide pact. There are times where we do need to, the government may have a legitimate basis for restricting individual rights. And at the federal government level, if you're going to restrict speech, and we're going to talk public forum only at this point, and public forums are where we would expect speech to be done, to influence others. That's typically what a public forum is. And we're also going to be talking, I'm not talking about categories of speech. We get into a lot of weird stuff when you start talking about, oh, them's fighting words, or all that kind of stuff, whether or not it's obscenity, all those kind of things, because you run into that thing where one man's F word is another man's lyric. Just some weird dynamics. We're not getting into that. Assuming all speech is protected, and assuming it's done in a public forum, the federal government, under the federal law, may limit speech if the speech interest is less, falls below a significant governmental interest. Okay, that's the difference. Significant governmental interest. If your significant governmental interest rises above your speech interest, the government may now put on time, place, and manner restrictions. They are not allowed to do content-based restrictions. That's a different scenario. But they can do time, place, and manner restrictions. And your interest in the speech could be partly based on its content. Political, obviously, is more important. Okay, but Washington's Constitution, we've decided significant interest, governmental interest, is not enough. Remember, we said every person can speak on every subject. All subjects. Every person can speak on all subjects. So under Washington's Constitution, if every person may freely speak, write, and publish on all subjects, well, that's higher than abridging that we saw underneath the federal. Abridging the freedom of speech, we've got higher words, more powerful words, broader in scope. And so we require a higher interest before the government can begin restricting protected speech in a public forum. And the interest we require is a compelling governmental interest. Now, some people may say, what's compelling versus significant? One is definitely higher. Compelling has a word to it that, man, I have no choice but to respond. It's not just significant for me to respond. I have no choice but to respond. There's threats to our society. And there's an interesting statement. I haven't explored this one as much, but underneath the federal government, it's a significant governmental interest. Underneath our state government, it is a compelling state interest. Remember how in our last discussion, we talked about the sovereignty of Washington remains in its people, and they almost loan it to the government. So, and I should have put compelling state interest. I left compelling government interest, but it's actually the words are compelling state interest. So what level does it become a compelling state interest? So that's one of the significant differences between Washington's Constitution and the federal Constitution. Underneath Washington's Constitution, in order for the government to restrict speech in a public forum, protected speech in a public forum, which is a lot of our speech. It's this here right now. Before the government can do that, it must have a compelling interest. That's high. And that's what's meant behind those words of every person may speak freely, write, and publish on all subjects. It is, man, if you're going to stop that speaking freely and you're going to limit one of our subjects, you better have a compelling interest for all the people of Washington. And that kind of brings me into one of the other purposes of speech. In Washington, one of the purposes of speech is to participate in the freedom, participate in the political process. Remember Section 1 of our Constitution, all political power remains with the people. Well, that's an important piece. I was talking with a friend of mine who was talking about their freedom of speech, and they were talking about something that I don't like to hear. And I looked at them, I said, and they're like, what if the government restricts me? I'm like, I would intervene, because your freedom of speech is not just for you to speak, but it's for me to hear. as part of the political process, if we're going to have in Washington a good functioning government where all the political power remains in the people, it's not just important that you be able to speak. It's important that I be able to hear diverse opinions that may or may not be considered harmful by someone else. Because if I'm to be part of that political electorate and part of that power, I need to hear and be able to filter in and out opinions that you may or may not like. And I may not like them. I may hate that opinion. But part of my right to be part of the political process is to hear it. And that's why it's on all subjects. It's part of the democratic, part of the political process. If the political power is to remain in the people, the absolute freedom of speech inside the public forum is important, because what if that idea struck something new for me or for you? So the freedom of speech is not just yours, it's mine in the right to hear. Okay. So we've talked through, that's one of the first ones, the difference in the Washington State Constitution. We require a compelling interest before the government can restrict speech in a public forum that is protected. And underneath the federal Constitution, it's a lower, it's a significant interest. One of the other key pieces, and we started off with the Coe case, is the second piece. And that could be really misinterpreted. Every person may freely speak, write, and publish on all subjects, being responsible for the abuse of that right. So what does that mean? Does that mean the government can punish you for your speech? Well, the answer is not really. This rolls back a little bit as well. I don't think I brought this up in the Alderwood one, but in the Alderwood one, we get into, actually, I'm sorry, this isn't the Alderwood one. This rolls into a few other cases. The concern about being responsible for the abuse of the right was whether or not there would be an interference with libel and slander cases. You see, one of the key things that's never protected speech is libel, slander, falsehood, lies. So part of this being responsible for the abuse of that right was much of what our founders in our state thought of the freedom of speech right was the best way to protect against libel, against lies, is through the libel and slander process. And so when they wrote this in there, they felt like this was highly important. So what we have is this case. I put State versus Coe. And State versus Coe, for those who are from Spokane, Washington, you will remember the South Hill rapist if you grew up at my time. I remember when I was very young, there was comments about the South Hill rapist, how he was coming around the South Hill during my early years. And I remember I thought he was the South Hill rakist. I had no idea what a rapist was. And I thought he was just someone who hit you with a rake. And I even told my mom, hey, if he rakes me, I'll hit him with a rake too. But so that was Kevin Coe. And if you remember what was going on, they wanted to bring all these cameras into and his mom had actually tried to hire someone to kill the judge. And so this was a big deal in Spokane. And they wanted to bring cameras into the courtroom because this was relatively when cameras are beginning to come up as a thing in courtrooms. And the judge orders they're not allowed to publish these. They're allowed to videotape it, but they're not allowed to publish it because he's concerned that this is going to interfere with the right to get a fair trial. If you publicize the trial, well, that interferes with the right to get a fair trial. And so the court allows them to record it, but says you're not allowed to publish these until we agree to it. So it puts a restriction on the speech before it occurs. And that's the key thing of being responsible for the abuse of that right. And that's where our court comes out with something that's interesting and different. underneath the federal government, you are almost always allowed to, I mean, there are these pre-restrictions on rights, on speech. You are allowed to do injunctions on certain things. But underneath our Constitution, the courts come out and say, appellant correctly points out that unlike the First Amendment to the United States Constitution, the plain language of Article 1, Section 5 seems to rule out prior restraints under any circumstances, leaving the state with only post-publication sanctions to punish abuse of the free speech rights. So that's something you're going to see inside our Constitution that's different than the federal. The federal does allow for free restraint of speech in certain sections, but that you are not allowed under any circumstances to restrict speech in the state of Washington beforehand. Post-publication sanctions are what is required. So that's another significant difference here. And you'll see in there, it says protected speech. I did put that up there. I want to make sure we still in Washington consider certain categories of speech, such as incitement of violence. And those are imminent incitements of violence there. So that's a whole thing different. But such as pornography or obscenities, fighting words, things like that, those aren't protected speech. But protected speech under any circumstances, post-publication sanctions only, no restriction ahead of time. So those are two of the key differences you're going to see inside Washington's Constitution on freedom of speech. But one of the things I want you to take away is underneath Washington's Constitution, it has a higher protection of speech. And actually, we in Washington refer to it as a preferred right. The freedom of speech in Washington is a preferred right. And that absolutely makes sense. If we're going to maintain that the political power of this state remains with the people, freedom of speech is absolutely key and crucial. It's your first and foremost. It's not just my freedom to speak. It's your freedom to hear. And regardless of you liking the content, regardless of someone else liking the content, if we're going to remain political power in the people, we got to protect the freedom of speech, and it must be a preferred right. Okay, thank you very much. I hope that to do a video here shortly, talking to a few other people on what they think of this freedom of speech right in Washington, and maybe we can do another one of these. I hope to see you into the future as we explore more. If I do my next course, or teaching where it's just me, it will be on the separation of powers. And we're going to look through a case called Cloven versus Inslee. Interesting 5-4 split, and we'll talk through some of the separations of powers. Thank you.